I'm a railroad injury attorney addressing the topic of accidents that occur off railroad property in vans, taxis, jitneys, or even hotel lodging. We have handled a number of cases involving circumstances where railroad workers are hurt in a van or taxi. And this is considered, under the law, an operational activity of a railroad. It is a railroad arranged ride or taxi service, and if the taxi service driver is negligent or careless, the law considers this an act of the railroad that employs the railroad worker. Under the law, the railroads have what is called a non-delegable duty. That's a mouthful, and that means that the railroads cannot delegate away the duty to transport workers safely. So if a taxi or van service or a lodging at a hotel is negligent or careless, that act is deemed to glomp right onto the railroad as though it was done by a railroad agent. What is the effect of this? It means if we represent you as a railroad worker in this type of serious accident, we have a choice. We can bring a lawsuit under the Federal Employer Liability Act against your employer, just as if they were driving the taxi or van or that they owned the property in question, and the careless act is considered the careless act of the railroad. In some circumstances, we choose to bring the railroad as a defendant along with the van service and make both defendants, even though the law that will apply to the van service is slightly different because it doesn't fall under this federal law called the FELA. We have handled a number of these types of cases, and you do have to sort out several legal issues. If we can help you with a question or with a claim, please fill out a quick contact form on our main law firm website or call our toll-free number. Thank you for listening in.